Hi, I'm attorney Gregory Dell, joined by attorney Cesar Gavidia, and we're going to talk about one of Cesar's resolved cases against Mutual of Omaha. And Cesar, in these cases, we like to talk about the background and history of the case, how you were able to be successful on behalf of your client, and then provide some tips for people that may have a Mutual of Omaha disability claim. So let's get into the background of this particular case.
So Greg, in this particular case, our client was a quality assurance manager for a medical device company. So you could kind of, just by the title of her job, you could tell how important, being able to work at peak levels and being able to effectively do her job would be. I mean, a medical device company that's producing these products that are going perhaps into people's bodies or being used to perform surgeries or any number of procedures. I mean, so her job is very important. And in terms of what had happened with her, she developed what perhaps to most people would be a benign issue after being corrected. She experienced a tear in her rotator cuff in her right arm and her dominant arm. She went for surgery, but didn't heal properly. She went for a subsequent surgery, and her condition got even worse. It developed what's called adhesive capsulitis in her arm, which basically created these permanent range of motion restrictions and a permanent pain condition, a chronic pain condition really, and could only move and elevate her arm to a certain level. She filed for disability with Mutual of Omaha, which was her group disability insurer's disability plan, and they had approved her. They approved her for about 10 months, so just a little under a year. And at that point, they did a medical review, as we often see in most cases. And the medical review that was done here was done by a nurse consultant. So it wasn't even done by a medical doctor. And they did a vocational review, which was done by one of their vocational consultants who essentially reviewed her occupation and the physical demand of her occupation, which they determined to be a light level occupation. After the nurse review was done, they sent the opinion, and this nurse said there are restrictions, but I think that the restrictions here would allow her to work her light level occupation. She sent the opinion to one of her main treating doctors. The doctor didn't respond, and her benefits subsequently were terminated, so they were cut off at that point.
So before we get into what you were able to do on the appeal, right when she called you and you read the review, was there something you were thinking could have been done differently to have avoided a denial?
Well, the one thing that we certainly like to ensure is if there's some opinion that comes from one of the insurance company's medical consultants, in this case this nurse, and it's being sent to the client's treating doctor, you want to make sure that it's addressed. You don't want it just to be a silent response or no response, because what happens is the insurance company then basically turns that on you and says, it looks like your doctor's in agreement with us. They're not responding to this, so they must agree that these restrictions and limitations that our consultant says you have are appropriate and it would allow you to work. So I think what I would have wanted to do is this preemptive measure of at least getting the doctor to respond. You don't necessarily want them to respond directly to the insurance company or to their medical consultant unless you're absolutely 100% sure that they're going to convey accurate information, or perhaps not have their opinions twisted around by this medical professional that's calling on them. But that's one of those preemptive things I certainly would have looked into if we'd had the chance.
And how is it that Mutual of Omaha was able to rely on a nurse when your client was treating with an orthopedic surgeon who had not only done one surgery but two surgeries and was restricting her from doing any work?
Well, insurance companies rely on these medical professionals all the time. So, these nurse consultants and sometimes these physicians work in-house within the insurance company. It doesn't cost the insurance company anything to do a medical review when it's in-house. If the medical review, in their view, looks reasonable enough, which they basically said that in their letter, we find that our nurse consultants providing reasonable restrictions and limitations. However, those reasonable restrictions and limitations apparently would allow or have her going back to work when she couldn't. But they do that all the time. There's nothing necessarily that prevents them, because the law isn't clear that the insurance company has to use physicians or that they have to use a particular specialist. It could be something down the road where lawyers may argue it wasn't reasonable for them to use a nurse, or wasn't reasonable for them to use a physician who wasn't specialized in that area of disability. But there's nothing in the law that prevents them from doing it.
Well, we always find it outrageous and unreasonable that companies like Mutual of Omaha do this, is to say, look, we used a nurse who works for us to review the files, and she determined that you're not limited, even though she never spoke to you, she never examined you. And in reality, what we've always said to each other is, it's okay, you have your nurse. Luckily, you have someone who at least has some experience of looking at medical records. But if your nurse who works for your company, Mutual of Omaha, reaches the opinion that this person doesn't have restrictions, then maybe you should say, let's have a doctor look at this person, or let's have an orthopedic surgeon who has 8 more years of schooling and training than the nurse to say, is it reasonable that this person has these limitations?
Right, and I mean, you could play the Monday morning quarterback, but I think that had her doctor responded, I bet you that would have been the second step before Mutual of Omaha would have cut those benefits off. You probably would have seen them say, okay, her doctor responded to our nurse. Now we should bring in our own physician to do a review of this opinion that the doctor has. That may have been something they would have done, but I think they found this easy out. This nurse did this review, the doctor didn't respond, let's take the opportunity and cut these benefits off.
Well, that's the whole point. Anytime any insurance company, not just Mutual of Omaha, has the opportunity to find any excuse that they think is slightly reasonable to deny a claim, they're going to do it. It's going to buy them time of not paying out money and possibly make a claimant go away, and then they'll see what happens. You talked about this as a shoulder injury, and it's a manager, and we don't know, and it was classified as light duty. And you've handled a lot of shoulder cases on behalf of claimants, but they can be challenging claims because often the disability company argues, well, we understand your shoulder's limited range of motion, maybe what you can lift, but we still think there might be a sedentary type job that you can do. So how did you overcome that in this particular case, and what was your strategy in the appeal?
One of the things that we were quick to point out was that when the nurse did their review, really the review was flawed. There were certain areas, particularly within her medical records, which showed that the restrictions and the range of motion restrictions in particular were not as the nurse consultant was essentially representing them to be, or stating they were, and it was pretty glaring. I mean, you're talking about 20 to 30 degree range of motion when 90 degree is normal, and that's right in the medical records. And what I did was I actually took out illustrations, and you could find them, in medical journals and different places where it shows, what a certain, degree of range of motion is. And I put those right in the appeal as an illustration, as a visual aid for that claim reviewer, that medical reviewer on the appeal, to see where her specific level of limitation was there. And that was one of the strategies that we used. And look, I didn't think it was necessary to go about a functional capacity exam in this case, because the medical records essentially were that functional capacity exam. Her own doctors were testing that range of motion when she was going in to be seen by them, and they were right there in the records themselves.
Was range of motion limitation on its own enough to prove that the claimant was disabled?
Well, I think it went to the credibility of her complaints, right? I mean, this is what they found in terms of how the extent of her ability to move this shoulder. There's pain. The objective evidence through MRIs and scans that she had done of her shoulder show that she has a frozen shoulder there, show that restriction there and the capsulitis in there. And I think that really was where the credibility behind her complaints came from. They were able to line up the subjectivity of those complaints with the objectivity of what was represented in the records, and we were able to illustrate that through our appeal, bring it all together.
How relevant were her pain complaints, and how did that contribute to her inability to work?
I think once all the pieces matched up for them, and they reviewed all this on the appeal, and they noted and saw that they were incorrect, that at that point they said, yeah, of course these complaints are credible.
And were you able to go back and work with her treating doctor?
So from that point forward, we were. These things, even when insurance companies reach out to doctors, If you talk to most of the staff at these doctors' offices, doctors are busy. They're not able to see every piece of paper that comes through their fax machine or in the mail to them. They're not able to certainly attend to a phone call when it's just, impromptu and it's not set for them. So what we try to do and what we were doing in her case was when she was going in to see her doctors, she was getting the required forms completed at that point in time, so we weren't waiting, so we weren't caught basically coming back months later after maybe she had just seen her doctor, then her going back to her doctor and asking for forms to be completed and different things. So that's kind of how you could work with your doctors, kind of line things up to have things done and completed when you're going in to see them. When you're sitting down, you could have a conversation with them so that they understand, well, what are they asking me to complete here? What is it that are your subjective complaints, the objective findings? Let's talk about those things and answer these questions appropriately, because probably 90% of disability claims, the reason they're challenged or terminated is because something is done at that doctor's office that causes the claim to be interrupted or the benefits to stop. Either a form isn't filled out properly, or they say they reached out and they didn't get a hold of anybody and nobody responded, and the doctor says, nobody reached out to me, nobody contacted me, and it's their word against the insurance companies.
So I know in every client that we represent, anytime they get an attending physician statement, we always work with the client and the treating doctor to make sure that that form is completed in a manner that's going to provide enough evidence to support the disability claim, assuming that the claimant has all the symptoms and limitations that are needed. And like you said, these doctors are really busy. They're getting workers' comp paperwork, they're getting claim forms just to get paid, they're getting disability work, they're getting Social Security work, and they're often just giving it to a nurse or someone to fill out. And that's assuming it does get filled out, and not ignored like in this case. So it is helpful to always make sure you're on top of your claim. I know when we manage the claims, we're on that. It's our responsibility to make sure those forms are completed, and that's certainly something that could have avoided a denial potentially in this particular claim.
And when you're not under that time crunch, if you can get ahead of that, we could work with the client, their doctor, to make sure everything is done properly, and it's not just done in the haste of, you have to get it in a week, or you have to get it in by the end of the month, and the doctor may not have time to do it properly.
Right, and I know in this particular case that you were able to get the claimant back on claim. Claimant was getting paid for quite a while, and then down the road you were able to negotiate a lump sum settlement, which is another service that we offer, where basically it was a one-time payment, policy goes away, and there's no more stream of payments, there's no more worrying about anything, and it's a decision that every individual has to make whether or not it works for them, but this particular client was satisfied with that. And then the claimant down the road, if they recover or do something, they don't have to worry about the possibility of trying to go back to work with a disability insurance company looking over their shoulder, or possibly losing their benefits because they tried to work for 90 days. Because a lot of people don't want to not be able to work the rest of their life. They'd love to try, but often these disability policies limit their ability to do that because they'll lose their benefits even if they try. So that was another great outcome in this particular claim. So if you're someone who has a Mutual of Omaha disability claim, whether it's short-term or long-term disability, feel free to reach out to Cesar, myself, any of our disability lawyers. We always provide an initial free consultation, and we look forward to helping you in the future. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.